Good morning, everyone. Oh, sorry. Good afternoon. It's 12:01. Good afternoon. Happy to be here. Thanks for coming to Bond's weekly business in 2024 webinar. And we have another great lineup for you today. I'm going to start things off. For those of you who attended 2 weeks ago, Laura Harshbarger and I did a deep dive into the Clean Slate Act, and the questions we received were overwhelming. And so I'm going to spend some time this morning this afternoon, answering a few more of those. Then we'll move on to our cybersecurity gurus here in the Syracuse office, Amber Lawyer and Shannon Knapp, to talk about cybersecurity best practices for policies and procedures. Nick Jacobson's back again this month with us to give us a litigation update, talking about some trends with our administrative agencies that enforce anti-discrimination law. So that would be the EEOC and the New York State Division of Human Rights. Then we'll finish things out with our associate Katie McGraw out in Buffalo, talking about an interesting development in the world of artificial intelligence, a topic that I feel like we touch on in this webinar quite regularly, at least on the weeks that I've been hosting. So with that, I'm up first. So I don't have any slides. We had 600 people attend that webinar 2 weeks ago related to the Clean Slate Act, and with that, over 80 questions. And Laura and I tried hard to answer them real time, but we just didn't have enough time. And so I just wanted to go over a few of the concepts. A lot of the questions were repeats, which means multiple people are wondering the same thing. So I wanted to make sure we got out as much information as we could. One point of clarification. There was a question as to whether the requirement that you give a copy of a background check to an applicant happens no matter what, including when it's a clean background check. And Laura and I might have said that if it was a clean background check, that you still have to do so. We're going to revise that advice here. After looking at it more closely, what the statute says is that you have to provide or ensure the provision of, quote, criminal history information. And if there is no criminal history on a background check, if it's completely clean, I think we can reasonably say that there's no need to provide that essentially empty document to an applicant. But you do have to make sure that you provide that to every applicant if there is a hit, so if there is some sort of conviction on there. And just a reminder, we said this last time, but you need to include a copy of Article 23A of the Corrections Law, as well as a statement that explains their right to be able to correct any incorrect information on the report with the Division of Criminal Justice Services. Okay, so wanted to clear that up. Another question that we had related to that was, if we're a type of employer that runs finger-based print checks with the DCJS, do we have to provide a copy of that? I think you do. Under a straight reading of the statute, like I just said, it says you provide criminal history information. If you're getting that information from a private background check vendor versus the DCJS, it's still criminal history information. So I do think that you would need to set up a process to provide that information. Next, a common question that we got, I think we might have addressed this, but I'll just reemphasize it here. Should we be telling candidates not to report sealed convictions? Generally, yes, because, again, sealing means it's as if it never happened. However, if you are one of those employers that I just mentioned who conducts fingerprint-based background checks with the DCJS, those sealed convictions are still going to show up for you. And so you would not want to put that on your application. So it really is an industry-specific, job-specific question that you need to look at for your organization. Just wanted to make sure I was clear about that. Thoughts about removing the question from an application and just asking the question during an interview. That was a question that was raised. I just want to remind everyone about the ban-the-box jurisdictions, in particular New York City and some of our upstate cities where you cannot ask that question pre-offer. So I just would be very careful if you're asking the question in an interview. I think the way the question was worded was perhaps a second interview. Maybe you could do that. I just would be very careful about how that question is worded, and make sure your interviewers are very well trained. And if you're statewide and you have multiple locations, I think you want to be careful about what the rules are in each particular jurisdiction. Okay. Another question that we had, a lot of questions about how the mechanics of the sealing, like what happens under this scenario and that scenario. Just a reminder, it's not something that you as an employer need to worry about. The sealing will be done by the state. You don't have to go through that exercise yourself. But I will answer one question which was repeated, which is what happens if there's multiple convictions? if the most recent conviction hits its expiration date, the 3 years or the 8 years, do they all go away? And the answer is if they all meet the criteria, yeah. But you judge the most recent conviction. And once the most recent conviction is aged out, eligible for sealing, everything that's older than that would also be sealed. Let's see here. A few questions about who's going to let the applicants know about this. Like, how are they going to know this whole concept of sealing and whether a conviction is sealed? Like, how do they even know? It's not on us. That's the most important thing to say. It's not on us as employers to communicate that information. There's been a lot of public outreach that I've seen online. The state has been holding meetings in various places, inviting people to come and learn about this law, people who do have a criminal history. So there's been a lot of outreach. It's really on the state to try to explain this. I don't know if they get a notification that something's sealed. I honestly, not quite sure the mechanics of that. But I think the bottom line is that that's not your role. Now, if someone doesn't understand and does report a sealed conviction on an application, you just have to be very careful and apply a Article 23 analysis. And if it's something that just from the eyeball test, so someone says, yeah, I was convicted in the year 2000, you're going to be thinking, well, this is pretty old. I don't know whether it actually is sealed or not. I have no way of doing that, but you just have to really carefully apply that Article 23 analysis. And I think, as we mentioned last week, the public policy element of that test, the public policy of the state to reemploy those with convictions, it's going to weigh very, very heavily in anything that appears to meet the sealing criteria. So be very careful about rescinding an offer or failing to make an offer on the basis of a very old conviction. Again, these are all very fact-specific situations, but as a general matter, I would say that to be the case. And just a couple more things. I don't want to spend all day on this, but a couple more things on page 2 of my notes here. How do we ask about gaps on our resume? And I think that's a really great question that, frankly, I hadn't thought about yet. If someone, was convicted and incarcerated, there is going to be a gap of time on their application or on their resume. And there's nothing stopping you from asking what you would always ask a candidate, which is, I noticed there's a several-year gap on your resume. Can you explain what you were doing, during that time period? And it's not illegal to ask that question. It's a very neutral question. It's a very legitimate piece of information that you'd want to know. It's up to the candidate to figure out how to answer that. If they do say that it was a conviction and it's been sealed, then there you go. It's been sealed, and you just wash that out of your brain. You don't take that into consideration. But again, it is okay to ask that question. And again, if you do learn information, you just have to go through that very careful Article 23A analysis. And if another question we had is, what if someone, is convicted of a crime, say a sort of a financial crime, for example, and it's aged out, it becomes sealed, you don't know about it, you hire them, they commit the same crime against you as their new employer. Any recourse against New York State, as tempting as that sounds, there is no such recourse. That would be an unfortunate situation, but nothing you could do legally with respect to the state. A similar question, though, is, and I think we covered this, what about a person who commits, again, let's say a financial crime, commits that crime, it's sealed, you don't know about it, you hire them, and then they steal from a third party. And then that third party wants to bring an action against you, the employer, saying that was very negligent of you to hire that person with that background and put them in the situation of trust with money. And there is a protection against liability in the law in that scenario. In that scenario, the employer, you would not be liable for a negligent hire because there's a specific carve out in the Clean Slate Act that makes sure of that. So those are some of the questions that we received. I think I've covered most of the concepts in the question, maybe not your very specific question. You can always reach out to me individually if you want to chat some more, run a particular sort of scenario by me. My email is in the slides, but it's ksmith@bsk.com. Happy to discuss any of this with any of you out there. So that's all I've got for now on the Clean Slate Act. We're going to move on to our next presenter here, and that would be two presenters. So we have Amber Lawyer, Shannon Knapp, who I mentioned, who are both in our Syracuse office and specialize in a topic very important to our clients, especially when something bad happens in that world, so cybersecurity. So thanks, Shannon. Thanks, Amber, for being here.
Thanks, Kristen. Thanks for having us. Good afternoon, everyone. Shannon and I wanted to jump into the webinar today because we just concluded Cybersecurity Awareness Month in October. And it's really a good time for companies, businesses, organizations generally to review their cybersecurity procedures and policies, to take a look at your data hygiene, to make sure you've got proper insurance in place, and to make sure that you've implemented policies and procedures that are understandable, workable, et cetera, et cetera. So we thought we would hop on. We'll talk a little bit of best practice tips today. Of course, there are very industry-specific, sector-specific privacy policies, cybersecurity policies, and procedures. We can't go into too much detail for all of those, or we would be on the webinar for many hours. But if you have any questions, feel free to reach out and follow up with us, and we can help you through that. Okay, next slide, please. Shannon, you want to kick it off?
Sure. So one of the first things we want to talk about was why having cybersecurity policies and procedures is so important. And there's a lot of reasons why, but we're just going to hit on a couple of them. One is to meet your legal obligations. And so depending on the industry that you're in, you might have higher legal obligations than other industries, such as like the financial sector has a lot of legal obligations related to cybersecurity and data privacy, as well as data retention and things like that. But even if you're not in a highly regulated industry, but you practice, your business is located in New York State, you still have some obligations under the New York Shield Act to comply with certain cybersecurity requirements, which includes having certain policies and procedures in place. So cybersecurity policies and procedures are a good practice to not only meet your legal obligations, but to do things like prevent data breach and mitigate the harm of a data breach. So if you have cybersecurity policies and procedures in place, like an incident response plan, retention policy, an overall written information security plan, things along these lines, it helps prevent breaches because you have a plan in place to make sure that, or to do your best to prevent a bad actor from coming in and breaching your system or causing harm. And then in the event something does happen, having policies and procedures in place can help you react appropriately and try to limit the harm as best as possible. And then in kind of the same vein, it allows you, in the event of a data breach occurring, having a solid incident response plan, figuring out how to react. If it is to the disaster level, you have like a business continuity and disaster recovery plan to help the company or organization know what to do when everything is shut down, when it's a ransomware attack and you can't access your systems, you can't function and things like that, and trying to get things back up and running in the best way possible. So it's both cybersecurity policies and procedures are helpful both from a reactionary perspective, but also from like a proactive perspective.
Yeah, great. Thanks, Shannon. Taking a quick step back. So when we're talking about cybersecurity policies and procedures, we're really talking about policies in place that set out that game plan that Shannon's talking about. So in the event of an incident, do you have the key stakeholders listed that need to respond? Do they understand how they need to respond? Who are your decision makers in the event of this crisis? What's really important to know, and I think we've seen this a lot in the last few years, is that, of course, no one is expecting a cyber incident to happen to their business. But having a plan in place really mitigates the risk that Shannon's talking about, and it helps expedite a path forward. So it helps you resolve issues quickly, efficiently, hopefully at a lower cost. And it's really important to have those policies in place, the procedures outlined, and that individuals understand them. The other thing it does is it really establishes your organization's credibility. So if you have an entity that partners with other institutions, your clients or other businesses, they're really coming to expect that you have these policies and procedures in place. In fact, they may demand that you have these policies and procedures in place. They may require contractual language relating to these policies. And so it really helps establish your organization's credibility, that you have a cybersecurity plan, and that you have a good security posture in order to handle and process personal information or sensitive data. Along with mitigating the harm of a data breach, having these plans in place can help mitigate risk of litigation. So what we're seeing is that although many state breach statutes do not have a private right of action, meaning that an individual cannot bring their own lawsuit, we are pursuant to the statute, we are seeing very creative litigation in that individuals are bringing suits saying, company X was negligent because they didn't have appropriate policies and procedures in place. And so having these plans in place are a way to mitigate that litigation risk. We can rely on your policies and procedures. One important note, however, is that if you do have a policy and procedure in place, you must comply with it when responding to an incident. And that seems obvious, but it is difficult in an emergency situation like a cyber event to ensure that you are following your policy. So making sure your key stakeholders understand that is really important. And then finally, these types of policies and procedures, if you have to comply with the law and implement them, it's really helpful to prevent any kind of regulatory penalty or fine. So if you do have a cyber incident, and let's say we have to report to the New York State Attorney General or to the Massachusetts Attorney General or whatever jurisdiction is relevant to your incident, that attorney general may reach out and ask to review your policies and procedures. And if you had appropriate procedures in place and the incident could not have been prevented and you followed them appropriately, you're unlikely to receive a regulatory penalty or fine. The state may just say, okay, you need to update your technology, or we need to try to prevent this in the future. If you are violating your policies and procedures, or you didn't have any in place, you are much more likely to face some kind of regulatory action. Shannon, anything to add there?
No, I think that's good.
Okay, next slide, please. So we'll just talk about this briefly. I'm going to kick it over to Shannon. When we're talking about policies and procedures, we mentioned this at the top here, but oftentimes we're now seeing either previous laws or newly effective legislation that mandate cybersecurity policies and procedures. That's often in a sector-specific way. So Shannon, why don't you kick it off and talk about GLBA and DFS?
Yeah, so as Amber mentioned, there's sector-specific laws that require certain policies and procedures to be in place, including like the Gramm-Leach-Bliley Act and New York Department of Financial Service Cybersecurity Regulation. Both of these are more targeted towards the financial sector, although they can have broader implications depending on the type of data you're processing. For example, certain portions of the Gramm-Leach-Bliley Act apply in the higher education realm of things, and certain entities, if they have to like register with the New York Department of Financial Services, would also be governed by the cybersecurity regulation. So though a little bit more sector specific, they do also can apply a little bit more broadly than you'd think on the face than they do. And then on the broader side of things, as I mentioned earlier, there's the SHIELD Act, which is the New York Stop Hacks and Improve Electronic Data Security Act, which applies to basically any organization that's doing business in New York State and is collecting the information or maintains the information of individuals located in New York. This includes employees, not just like customers or consumers or anything like that. So if you have employees in New York State, you're getting pulled into the SHIELD Act, and there isn't really any sort of threshold limitation. There's like small businesses are included. It's just a little bit of a different standard.
Yeah, we see the same sector-specific analysis in HIPAA. We won't do a deep dive into HIPAA, but that's there as well. And then finally, in consumer privacy law. So we are seeing consumer privacy laws now. We have 18 states that have effective privacy laws. Those all mandate certain cybersecurity policies and procedures as well. Okay, next slide, please. All right, so we'll just briefly touch on some best practices and tips in relation to your policies and procedures, what you want to do when implementing these types of policies, and then how to maintain them as well. So first, very important point is that it's not a one policy and check the box type of game plan here. It's multiple policies, plans, and procedures to have a comprehensive cybersecurity program in your business. What does that mean? It includes policies for employee training, policies in relation to incident response, data retention. So how long are you keeping information? And that can be data retention from your inbox to employee applications, to jump back to Kristen's discussion. So you need cross-contextual policies and procedures that provide for comprehensive cybersecurity. It's not just one area or one lane. You want to make sure you have multiple procedures. Shannon, go ahead.
Yeah, another important point is adequate employee training. Most reports that come out every year show that human error is one of the largest causes of cybersecurity incidents. And so having policy and procedure around proper employee training, making sure that training is required and that people are completing it, and learning ways to properly have tech hygiene, how to spot a phishing email, things along these lines is very important to help prevent cybersecurity incidents.
Yeah, and then, you know, what's also really important, and I think is sometimes overlooked, is making sure you're doing adequate vendor due diligence. So every business here now hires vendors, right? From your printer company to your payroll company to your software provider. All of those vendors that may touch any kind of personal information, sensitive information of the company need to be properly vetted. So when we were talking about credibility, we want to ensure those vendors have credibility, that they will protect your information, and maybe ensuring that in contractual obligations as well is really important. All right, Shannon, do you want to wrap it up with periodic review?
Yeah, so lastly, the last one I'll hit on is it's really important to periodically review and revise your existing policies, or to put policies in place. The law continues to change. The technology obviously continues to rapidly evolve, especially with like AI that Katie will talk about in a little bit. And so at least annually reviewing your policies and procedures and revising them if appropriate, also in response to like risk assessments and things like that, is a really important step to take to ensure that you're protecting your organization as best as possible.
Great. Kristen, we'll turn it back to you.
Got it. All right. Thanks for that. Thanks for the very appropriate wrap up to Cybersecurity Month, even though we're 5 days late, but that's great. All right, turning it next over to Nick, who's here with another litigation update, telling us about some trends out there with the administrative agencies. Take it away,
Thanks,
Nick.
Kristen. Next slide, please, Kathy. All right, so today we're talking about some litigation trends that we're seeing with our administrative agencies. And we know that we have clients in different states, but the majority of you are here in New York. So that means at the federal level, everyone has the Equal Employment Opportunity Commission. But here in New York, we've got the New York State Division of Human Rights as well. So we're going to take a look at some of the statistics they put out for 2023. So starting with the EEOC, there were over 81,000 new charges of employment discrimination filed with just the EEOC in 2023. That's 10% more than there were in 2022. And here in New York State, over 9,500 charges were filed. And that's a significant increase over the amount that were filed in 2022. And really a trend that we've been seeing since we've kind of come out of the COVID pandemic in 2021. The most common allegations that the EEOC sees in its charges are retaliation, coming up in more than half of the charges that it receives. In terms of disability discrimination leads the pack in terms of most complaints filed at 36%, with race discrimination and sex discrimination behind, also in the low 30s. Age discrimination, also a significant amount at 17.4. All other categories were less than 10%. And I think, it's valuable to look at these numbers because, it gives us an idea of the areas we need to be particularly careful in. One thing I'll note also is that in 2023, that was the first year that the Pregnant Workers Fairness Act was in effect. It was in effect for only part of the year, but there were still some claims filed under the Pregnant Workers Fairness Act. There were 188 in 2023. I'd be shocked if that number wasn't substantially higher in 2024. Next slide, please, Kathy. The EEOC reported that it obtained over $440 million in settlements and conciliation for individuals employed in the private sector or by state and local governments. They had over 22,000 charges that they resolved last year. They resolved more than 370 systemic discrimination investigations. For those of you that might remember, I think it was my last update, might have been 2 ago, we talked about a home health agency that was the subject of a systemic discrimination investigation by the EEOC. So, just a helpful reminder that if we're dealing with issues of potential systemic discrimination, it's much more likely that the EEOC is going to investigate that and to potentially bring an action itself in relation to those issues. And the 370 systemic discrimination investigations that were resolved last year, the EEOC collected over 29 million in additional settlements. So, over $469 million the EEOC recovered from employers in the private sector or state and local government last year. Next slide, please. So the EEOC itself, as I mentioned, can file lawsuits and commence litigation itself. This year, there was a substantial increase in the number of actions the EEOC commenced. This year, it commenced 143 actions in federal court, up from 91 just a year ago. Of the actions it commenced, 118 were non-systemic, whereas 25 of them constituted systemic discrimination cases. Although the EEOC filed 143 actions, it resolved another 98, bringing in another 22.6 million. So very close to $500 million that the EEOC collected last year from mostly private sector employers. The EEOC also boasted a 100% success rate for its systemic litigation program, recovering $11 million for 806 employees who were alleged to have been the victims of systemic discrimination. So again, just really highlighting in their end of the year report their efforts to crack down on what it sees as systemic issues of discrimination. Next slide, please, Kathy. So the EEOC also boasted that it reduced its charge inventory despite the 10.3% increase in new charges this year. And this is really meaningful to employers because, here at Bond, we've been seeing cases take longer and longer to get through the EEOC process. So at first blush, this would seem like a very positive development that it's reducing its charge inventory. But unfortunately, if you take a look at the numbers, I wouldn't really expect things to change in terms of processing time moving forward, because the charge inventory was reduced by only 300 cases, which would represent an amount equivalent to 0.0037% of new charges filed this year. So not a very significant change there. Next slide, please. So here in New York, in the Division of Human Rights, there were 7,629 complaints filed. That's a huge increase over the 4,865 filed in 2022. It's actually a 36% increase, so significantly more than the EEOC saw nationally, and more in line with the uptick in charges that the EEOC saw here in New York. So New York employers should be on notice that employment litigation matters are becoming more and more common here, whether it's with the New York State Division of Human Rights or with the EEOC. Like we saw with the EEOC, a little bit differently, but the same types of claims were the most common here. There was a significantly lower amount of retaliation claims, but disability discrimination still led the way in terms of being the most common type of discrimination claim, with race and color discrimination, sex discrimination, and age discrimination, all following and kind of closely mirroring the numbers reflected by the EEOC. Another thing that I thought was interesting in New York, 12.7% of charges filed with the division include an allegation of national origin discrimination. All other categories were, again, less than 10%. Next slide, please. So the Division of Human Rights last year in settlements and conciliations collected over $6.7 million, issued to over 1,000 complainants, which I think, one thing that you can see that's very significant, the number of resolutions versus the number of cases being filed. We'll take a little bit a look later at some statistics the division left out of their end of the year report here. And I think one of them is the percentage of cases they're resolving in a given year. But the total percent paid out, up 8% from last year, and continuing a 6-year trend of collecting more and more money for complainants. Next slide, please. So this was a chart that I thought would be helpful, perhaps for employers that frequently deal with these types of complaints in New York, showing the number of complaints resolved by region and the compensation that was paid out. New York City predictably leading the way with 299 complaints resolved for $1.8 million. As an attorney practicing in Rochester, I take particular note of the numbers in the Finger Lakes, which really aren't that far behind New York City, and certainly I think per capita would exceed what we're seeing in New York City. So certainly interesting to see the regional breakdowns, and it's difficult to really extrapolate why we're seeing such significant differences by region, but certainly a valuable piece of information if you're facing a complaint in a particular region. Next slide, please. So one thing the division seemed to put particular emphasis on in its end of the year report was the Division Initiated Action Unit. And that's a unit that works to identify and combat systemic discrimination by proactively investigating and prosecuting potential offenses and high impact cases. So very much following the EEOC's lead and looking to proactively bring these complaints itself on behalf of workers in New York State. The end of the year report in particular highlighted a complaint that was filed against Amazon, alleging that it discriminated against pregnant workers and workers with disabilities. by forcing them to take unpaid leave rather than continuing to work with an accommodation. I don't think it's really a shock, but the division found that its own complaint had probable cause, and the case is awaiting further proceedings. Next slide, please, Kathy. And finally, I did want to take note of some, I thought important omissions from their fiscal year report. One statistic that they left out was the rate of probable cause determinations. I think those of us that practice in Bond's Labor Department have seen, the rate of probable cause determinations, vary significantly over the years, from times where, a much lower percentage of cases were being probable cause to, during the pandemic in particular, when it seemed every case was receiving a probable cause determination. They did issue that statistic previously, but something they left out here, which I thought was interesting. They also left out the average processing time for complaints. It was over 570 days in 2021. They have not issued that statistic since. I think certainly any employers that are dealing with the DHR claim, and those of us here at Bond have seen processing time for Division of Human Rights complaints getting longer and longer and longer. And this year, when you see that they brought in over 7,000 complaints and only 1,000 were resolved, I would expect that number to continue to jump, and complaints to take longer to work their way through the system. Also, the division didn't issue any statistics related to public hearings, which also I think would have been useful, but unfortunately not something they're issuing anymore. But I think big picture, unfortunately, the takeaway here for employers is that workers are becoming, more litigious, and it's more likely than ever that as an employer, you're going to have to potentially defend against one of these types of claims moving forward. Thanks, Kathy, and thanks, Kristen.
And thank you, Nick. I often find myself wondering how in the world the division's ever going to climb out from underneath the pile of cases that they've issued probable cause. I mean, I know that I have cases sitting on my desk that have been waiting for a hearing for over a year easily. So I'm not surprised that they decided not to share their average processing time or their statistics related to hearings or the rate of probable cause determinations. I'm assuming others have the same experience, but they are incredibly behind.
Yes, yeah, I'm sure that's something they didn't want to highlight in their end of the year report. So
yeah, I mean, you can't start awarding probable cause and not increase the resources in terms of hearings. So we'll see. Okay, moving on to our final presenter, Katie McGraw, our associate in Buffalo, to talk to us about a recent determination by a judge involving AI. So tell us about it, Katie.
Thanks, Kristen. Hi, everyone. I'm Katie McGraw. I'm a litigation associate in our Buffalo office. I'm also a member of the firm's artificial intelligence practice group. I've spent a lot of time over the last few years getting very familiar with AI issues. I've spoken at a number of conferences, given CLEs on issues involving AI and litigation. And then I'm also a member of the Western District of New York, the Federal Court Local Rules Committee on the AI practice group. So I'm in the trenches on this stuff. Today, I just wanted to highlight a case. There was an article that was posted on the website, I believe a week or so ago, that I had written. It comes out of Saratoga County Surrogates Court, so a New York Surrogates Court. The facts of the case, just really briefly, were basically there was a trustee that was claimed to have breached his fiduciary duties with respect to a certain piece of real property that the trust owned. So the claim was that the trustee should have sold the property earlier and the trust would have had more profits if the trustee had done so at the right time. And then the issue that went to a hearing was the proper calculation of damages. So as is the case, in many commercial litigation areas, including trust and estate litigation, you need experts to opine on damages calculations. And the court, in this case, it wasn't a jury trial, it was a bench trial. So the judge will decide at the end of the hearing what, if any, the appropriate measure of damages is. So in this case, what happened was the objectant, so that's the person that was challenging the trustee's actions, hired an expert and had the expert had issued a report, an opinion, and then the expert testified before the judge to support the opinion and to claim what the calculation of damages was. And during the beginning of the expert's testimony, the expert testified that he had used Copilot in creating the or coming to the conclusion of the damages calculation. So Copilot, Microsoft Copilot, is a large language model AI tool. It's similar to ChatGPT. And the expert had testified that he had used it in preparing his damages calculation. On cross-examination, it had been revealed that the expert did not recall what prompt he had put into the Copilot in this case. He had come to a number, but he really couldn't give specifics on what information was fed to Copilot, how he got there. It didn't sound like he didn't save, you can kind of go into Copilot and save your conversations. That wasn't in the report. So this goes through, so his testimony comes out and then it goes to the judge to make a determination. What was interesting was, in this case, the judge took it upon himself to ask Copilot on 3 different unified court system computers, kind of the same questions that the expert could recall that he had input. So that the judge was essentially trying to replicate the calculation that the damages expert had done to try to see if he would come up with the same number. And the judge came up with 3 different numbers on 3 different computers. Each of those 3 numbers being different than what the expert had come to. So that was a real problem for the judges, you may imagine. And definitely, I think, probably inspired this long decision that the judge ended up writing on. So the judge had written, basically, I think it was like a 20-something page decision, but a large portion of the analysis related to the expert's opinion and whether it was going to be admissible. So in New York State, similar to federal courts, expert opinions and expert testimony is subject to, a baseline ruling of credibility, essentially. So in New York, we use the Fry standard. It comes from a case in federal court, it would be the Daubert standard. But basically, you have to scrutinize an expert's opinion and make sure that it's based on, recognized principles and things that are generally accepted and used in the expert's field of, expertise. So in this case, the judge had determined that because the expert was unable to basically recount what he had put into Copilot, given, I think, in addition to the judge's experiment himself with the inputting and getting 3 different answers from Copilot, he had determined that this expert's opinion would not be admissible. Because, and he didn't say, what's interesting, he didn't say Copilot's not admissible, you can't do this. That wasn't the flavor of this decision. It was that this should have been the subject of a Fry hearing. This should have been disclosed prior. Counsel shouldn't have been surprised on the stand. And then in addition to the unreliability that was apparent from this case, from this expert's opinion. So he tossed it out. And there's a note in the decision, which was the title of the article that I'd authored, was, garbage in, garbage out was what the judge had observed. Basically, if you're putting, garbage science or garbage damages, calculations in, you're going to get something in return that's potentially not going to be admissible in court. One interesting note was when I was asked to write the article, I kind of was, in an effort to maybe double check myself, but maybe cut some corners if I could. I asked Copilot, I said, hey, could you summarize this decision for me from the court? And Copilot literally gave me a 180-degree different angle of what the decision said. Copilot said, oh, the judge determined that Copilot is very reliable and that experts frequently rely on it in, the field of damages calculations. And, the court found that it was admissible. So that was just, another note that we should all keep in mind. In this case, it was rather comical, but, always keep in mind to be double checking, what Copilot is telling you. And then so kind of the takeaways from this case are certainly the judge was, very deliberate to say, I'm not telling you not to use that calculations, including, artificial intelligence aren't going to be admissible or that experts shouldn't use Copilot. The judge even recognized AI is everywhere. AI has utility in all sorts of fields and can certainly have utility in expert reports and in court. But you got to be careful and you got to subject it to the proper evidentiary hearings and stuff like that. So, for any litigators out there, just a couple of practical tips that I kind of have learned from this case. And I've been involved in other litigations too, including my own, cross-examinations of experts to keep in mind here are, so first, if it's your expert, right? If you're the one that hired the expert, you're putting the testimony on, you got to talk to your expert and say, are you using AI? What did you use? How did you use it? What did you input? Are you putting that in your report? This has to be a conversation because we as lawyers, like we may not even know. I mean, I'm certainly on, the lookout for these things, but it's very possible that you go ahead and hire an expert and they might not have told you that. And whether it's just to double check their work or, whatever, I do think it's really important. So that if that's your expert, certainly have those conversations. And I will note one thing on there is I practice a lot in New York courts, but I do practice as well in federal courts. Check your judges' rules. This is a new issue, and judges, as I've seen them, in the last year and a half or a little bit more than that, they are issuing individual rules. So I think this surrogate that issued this decision I was talking about, I think he's going to come out with a rule. I think that was kind of noted during the courtroom conversation. Federal courts are coming out with rules. Individual judges are putting into their part rules saying if you're going to use AI, you have to disclose it. So as is, the standard advice, always check your judge's rules, make sure you're following them. But then also just on the flip side, if you are cross-examining an expert, or if you have to, if you're looking at your opponent's expert report, ask these questions. So, think about, well, if it's not disclosed in the expert report, that doesn't mean they didn't use it. Again, this was a case where it was a surprise on the stand that this expert had used Copilot. So think about what you want to ask and say, what did you use? When did you use it? Did you use, ChatGPT, Copilot, or another one? What did you ask it? Did you ask it more than once? The same question. Did you get the same answer? It kind of sounds like these are really basic questions, but you'd be really surprised if you spend some time in Copilot or in ChatGPT yourself. These questions, if you ask these large language models these questions, you're going to get different answers. And this is something that I've learned from experience. I'm still learning. Obviously, Copilot couldn't write this article for me. I had to edit what it had told me. But these are the things that we have to be thinking about as the landscape changes here with AI. It's not something I thought about, very often before this case and before having, a recent other interaction with experts in AI. But it's just, this is going to come up every which way. This particular decision has been picked up, I think, nationally, just because it's a really detailed decision. But we're going to see more and more of this in all sorts of courts on all sorts of litigated issues, because they're hot topics and judges like to write on hot topics, and there's not guidance out there. So it's definitely something to keep apprised of. And, if I can just, close with one thing, it's, I'm not saying don't use AI, we use it. I do think it has utility, but it's always things that you don't think about that come up in ways that you're all of a sudden in court and you're not realizing this is going to be an issue. So just, read about it, talk to people about it, and just try to think through all the way take your case all the way through trial and think, well, where potentially has AI been used and how is this going to come out and how do we want this to look? So that's kind of it. We do, I think, as a firm, try to post on this stuff as much as we can because it is so new. So, certainly follow along. And if you have any questions for us, for me, for the AI, subcommittee group here, practice group, reach out and we can hopefully guide you through any issues you guys are having. Thank you, Kristen.
Yeah, thanks, Katie. I know we're over time here a little bit. Just one quick thing from me. And one of the questions that we had, I accidentally clicked the answer live button, even though I didn't answer it live. So it won't let me type in an answer. So someone asked, can we still advertise requires background check? And the answer is yes. You can still run background checks and you can still you know, let people know that you're doing so. So with that, we'll end things. Thanks for being here, and we will see you again back here next week. Thanks.